You doing?
I'm okay. How are you, Hank?
Good.
Please.
Thank you.
So, you already admitted probation violation, and the violation is alcohol.
Yes. Yes.
You're in Cara,
Yes.
and revocation is going to be a partial revocation of 20 weeks,
That's what I understand.
and that's also probably going to be expressed today as 140 days, as opposed to
Right.
because the system doesn't count in weeks,
Weeks, correct.
counts in days, years,
Right.
months.
Sure. Yeah. Yeah.
And Jerry and Megan made this deal, and Joe Alfred is coming today.
Sure.
Your probation is going to be amended so that you say you have a complete CARA.
Right.
You have to follow the recommendations from CARA,
Right.
and you have to participate in CURP.
Yes.
It's possible what your probation officer wanted, what Ashley wanted was IOP.
That's correct.
It's according to this that your probation, the way it's going to be worded is that your probation is going to be amended to follow the recommendations of CARA, which probably recommend participating in an IOP after CURP.
Yes.
But even if it did, there's nothing stopping you from doing it anyway.
I did it on my own last time. I was a week away from completing IOP
Right.
when this happened, and that was voluntary. I wasn't ordered to do that, so that's fine. I enjoy the program.
So,
And release upon completion of CARA.
yeah. Yeah, CURP is an out-of-jail program.
Yes, I understand that. Yep.
So, yeah, no,
I'm
CARA,
relatively familiar.
CARA, you get released, CARA, you get released.
Yes.
But my understanding is, while you're doing the CURP,
Mm-hmm.
you're still actually in the
Incarcerated.
custody of
Yes,
the jail. It's
yes.
kind of like a home arrest, or
Yes.
it's if you could be brought back to the jail by jail discretion,
Yes. Yeah, I understand.
rather than somebody having to file a motion
Mhm.
with the court to compel you to come back to jail.
Sure.
I mean, that doesn't really,
No.
but it's good to understand your status.
Yes.
When you're in CURP, it's the same as if you were in jail. Only it's better.
Exactly.
Where are you going to go after you get out?
Exactly.
Where are you going to be living?
Well, that's the thing. My fiance and I are together. Unfortunately, this incident happened because we got into an argument. The wording, there's no domestic violence issues, nothing. We've never had any issues together. This is actually our first tiff, so to speak. We've been together 6 months. Recently engaged just before I came in. So up on Drew Street, which was extremely convenient as far as getting to IOPs and my commitments. But the thing is, what I was talking to Sherry yesterday morning about was the way the complaint or statement was worded by Ashley Gabry is she held because Laura called probation.
Yep.
And Laura takes prescribed painkillers for some multiple issues, multiple injuries. And her doctor, Soderberg, I believe it is, in Richmond, knows that I was to stay on her count on what she was supposed to do on a daily basis. Laura found that she took a little too many. So when she went with Ashley, her speech was slurred, supposedly according to Ashley. So that threw up a flag. And when they came to the house to check on me, the 3 officers and the 3 separate POs, they interviewed me. I said, yes, I drank. I admitted it that morning, or early afternoon. Yes, I was drinking. I had a couple of beers last night and today. They didn't breathalyze me. They didn't draw blood. Nothing else. Fine, I admitted it. And I called Laura and she accused me of taking her prescription medication. So I wanted to clarify, no, I didn't take it. I don't do pills. I don't do anything else but drink. I didn't take it. I physically took it and took 2 pills and put them down the sink because I didn't want her to overdo it. I was like, so now, I guess, according to Sherry, they're saying, well, there may be an issue with how I was living there when I get out. And I don't see why. We've never had a problem before. It's a safe environment. I don't take pills. You know, her doctor entrusted me enough to make sure that she got what she needed per day and not any more. You know, it's not my thing.
Well, it is kind of like a blanket rule that you're not supposed to possess illegal drugs.
They weren't in my possession, right?
No.
And they're not illegal.
Well, they're illegal for you.
To consume. Yeah.
So it could be that the jail is going to, have a rule that says people that are in the jail. Okay, thank you. People that are in the jail are not allowed to possess drugs,
Right. Well,
so
yeah.
it may be that
I see what you're saying.
there may be a distinction between when you're on
I see what you're saying.
and when you're on probation. Although it seems to me, if they, this is just me, but if they want you to be successful, it would be easier to be successful if you could live with Laura and Drew Street.
Yes.
Because if you're not living with Laura at Drew Street, there'll be more stresses on you,
Thank you
than if you're living there.
Thank you very much. That's
So
my point
therefore
exactly.
you have more stress,
Mm-hmm.
and you're just coming out of
Mm-hmm.
a program that's very, very structured, and there's very little opportunity to do anything except the program. So there's very little stress.
Correct.
But once you get out in the world, there's a lot more stress. First of all, the mere fact that the alcohol is completely unavailable while you're in the CARA program, and completely available while you're not in the CARA program, you're out of the CARA program, even though you're in CARA.
Right.
Alcohol is 100% 24 hours a day available anytime you get the thought.
Absolutely.
And that is a tremendous stressor,
Mm-hmm.
that availability, and it would be good to be in a situation,
Wow.
imagine how tough it is for people when they're home,
Mm-hmm. Which I would be,
and it's cold,
and I would be.
and the only place that's open is companies.
Yeah.
You know what I mean?
Yeah,
It's
exactly.
like, all right, well, what am I going to do now? Well,
Right. Well, that's what I was thinking about last night.
I
Hank.
mean, these are things to really try to talk to the powers that be about.
I will.
And bring it up at the program, because obviously, aftercare is a very important part of any of these programs.
Indeed.
You know that from the IOP,
Indeed.
and you know that from CARA. In fact, the CARA aftercare program is so carefully structured that it's curved.
Right.
That's the aftercare program. This isn't we'll cut you loose, you go to a therapist here.
Yeah.
This is Kirk is almost as structured as Karen, except that you don't have the confinement.
Right.
But it's you know, it's like an IOP. It's like, and you should, you know, bring up with Kara saying, you know, I think it's an important part of me being successful in Kirk to have a place to live.
Yes. Well, they were mentioning maybe a shelter or a boarding house. Now, Laura and I are engaged. We've talked to Ashley Gabriel, my PO, about moving to Kentucky. Laura's from Kentucky. Ashley didn't put up any fight about that. She was actually willing. She had actually mentioned about how much money it would cost to transfer my probation to the Commonwealth of Kentucky. So, let's just say I get out of Kara January 15th to graduate. You say I can't go home, which I know is my home where I'm comfortable with my fiance. You put me in a boarding house, what do you think I'm going to do? And I can't have contact with Laura. What do you think that the first thought that may go through my head?
Yeah, well, you shouldn't say, what do you think I'm going to do?
No.
You could say, you know, it's going to make things a lot harder.
Yes.
It's going to make it harder.
Right.
Unnecessarily harder.
Agreed.
And I'm willing to, you know, you can come every day if you want, randomly search everything. You can test me every day. You can do whatever you want. You want me to report to probation and get tested daily, whatever you want me to do. But it's the winter in Maine. I think it'd be good to, you know, have a solid place to live where I can feel centered and emotionally grounded, and you know, have a good preparation for the next day. You know, it's one day at a time, but your nighttime needs to be a state that prepares you well for your next one day. And
Agreed.
When that is chaotic, with the uncertainty of shelters, if there's a rooming house, there are many different bad elements involved in rooming houses, and you know, it's just not a little too much too soon, I think.
I think so too. I've lived in a rooming house for 6 months.
Right.
It's just, it's as easy to get it as knocking on the door as it would be as home. And you knock on your neighbor's door, you can get whatever you want.
Right, and the people in the rooming houses are in these circumstances, many of them, because of drug problems have gotten them into this position. You know, if they were completely successful and drug-free, there'd be a good chance that they'd have a more stable place to live. So I don't know if people can see that, but
right. Well, I agree.
It does
100%.
make sense, and you know, you got to find somebody.
I've lived on the streets.
Mental health that kind of sounds sympathetic to this notion. I mean, hopefully it's not all decided yet, but
I don't believe it is.
But I mean, it ought to be, you know, say we really I need that plan. I need that True Street Laura plan, and let's put in whatever safeguards are necessary. I mean, you want to do pill counts? She'll do pill counts.
Absolutely.
You know, you want to have somebody.
She already does.
But if you want to send somebody over, you know, to count her pills, or you want her to bring her pills, or you want to check her prescriptions. I mean, I don't know what we can do, but it seems having a home is like really important.
Yeah, I've lived on the streets in January and February. It's not a good time. I'm satisfied with everything. I enjoy the care program so far. With 2 weeks, week and a half in. It's a lot.
Generally, the witnesses are sequestered. So no witness hears what the other witness says.
Okay.
I'm sure the judge does that on her own, but it's a good idea that one officer doesn't hear what another officer says, because then they tend to bolster each other's stories. me to sit? Do you want me to sit? Do you want this stuff kind of here on the table? Or do you want me to sit? This chair just, I can sit like back just a little.
That's fine.
Then I can still be able to, I'm going to pay to write notes on. And, that way you can keep this here. Introduction is 5 minutes on sitting up. We would say, yeah. Well, 5, she got 5 minutes. She's on the clock right now. Go sit that. I didn't set a 6 right now. I got a 15 maybe.
justify any of this. Two. Shaw and Glenn. What's the penis for Eric Dos Santos, who was in Afghanistan? Because he has nothing to do with anything.
Because he has nothing to do with anything.
Yeah, and how do you make that determination before you hear what he's got to say?
Was there a written motion?
Yep. And why didn't I get a copy of it?
What the issue with him was that his name was not listed on the witness list at the time of jury selection.
He wasn't even here. He was in Afghanistan.
You can say anybody.
Right, but he has no knowledge about this case at all.
Knowledge that's relevant, right?
Yeah, about this case. He wasn't even in this hemisphere.
What about
You guys are really digging your hole deep.
Gene's archive?
I told them we had to comply with it unless they heard otherwise. So this was Monday. I don't know who they brought with them, but... So my discovery's denied, my witnesses are denied, there's no evidence to prove anything. All the charges except one are dropped, except for,
As
yeah.
far as the motion
What a
to
joke.
quash, you should explain to the judge
Uh-huh.
why you think his evidence is relevant.
I certainly will be.
I mean, what the state's position is, he knows absolutely nothing about this crime. And your argument is not, you're not trying to get information from him about this crime.
No, I'm
You're
not.
trying to get other information. So you should explain to the judge.
Which is a companion case to this case.
You should ask the judge.
And it will
Tell the
show...
judge why you think it's relevant.
And it will show that the previous conviction was a result of duress and intimidation and coercion, because Officer DeSantos told me himself that there's a high likelihood that the DA would dismiss both of them because he knew that they were a result of a medical suspension, which is not a crime.
Let me,
So we are going to hash this out today. Seal says the suspension was for a conviction. The medical suspension had been rescinded by the conviction suspension came back. So it's not about a medical suspension. 2 years they expired a conviction for OAS. That she's PCR'd twice. And he was the officer in the underlying OAS. But this suspension might be one of the suspension and reason we just need to get that prior conviction. I still would have been
prior conviction would come to the attention of the jury.
how much thousands
Right.
of depends on exactly.
The judge, excuse me, Nick. Yeah. The judge would like to know if he would be done at 12:30.
As far as I'm concerned, it's okay.
12:30. busy, but he's a busy man. I want to get this out of the way. I think it's we may have to take just a little late.
You gonna say something?
Yeah, come here.
Not DeSantis, no. Not DeSantis. The reason for DeSantis' testimony is to corroborate that prior to his arrest, I had legal plates on my car. I had an awful license. I was an unlawful citizen. And his stopping me the first notification that I had that anything was wrong with my license. And he told me specifically, go talk to the DA. He will probably drop all of those charges and you have the person taken care of. I did what he told me to do. And the DA refused. Steve Parker refused. And Eric DeSantis was called into the trial on that day. And he confirmed that there was a medical suspension and that I was committing a war crime. And that the original stopped in February 2011 for less than 10 violation, and he couldn't give it to me. He stopped me twice in 30 days. Okay? He couldn't 10 for less than violation, at which time more vehicle could get away from me, could not get my license status. So he gave me a ticket the left turn and sent me home. Exactly 1 month later, on March 7th, I was in the exact same place because I was working out that area. He saw me. He stopped me for a specific reason. I could tell me that my license was on medical suspension. And this isn't sorry I have to do this to you, Jesus. But I have to pick it to you. Yes. Because remember that I have to pick the 2 of them. But today went for a month ago. This is what. If we call home and we take care of medical right now, this isn't going to have to be tomorrow. Jesus, I would like me to dismiss one and not both of them. Which I did exactly that. And after checking my motor, why is that relevant? Because I'm appealing that decision because I was coerced into a no-load plate. I did not intentionally plead guilty.
How is it relevant to whether you're guilty or not guilty this particular driving in February of 2012? How is it relevant to that charge? That's what the state would say. It's not, it doesn't, none of that is relevant to whether you had a license.
It's not.
And whether you
But
were driving.
Okay, it's not. So that's I agree. That's not directly relevant. But with regard to
Maybe
this,
it is relevant if they say you're refusing to submit to arrest. You
Well,
want to say that I had reason to believe I was being illegally detained, and Officer DeSantis is my evidence that I was illegally detained or something. I mean, there may be some way of...
is she pushing forward on all 7 charges, or just the OAS?
The 3 charges.
She's pushing
from
forward
Augusta.
3, but she said yesterday in the email that she was going to drop one, that she was dropping all of the OAS. So what happened to that?
No. She drops all of them except the OAS. If you plead guilty to the OAS, they're dropping the Oakland on their own and going forward on the 3
Oh, cool.
Augusta
Then I got a
charges.
better chance of kicking it
So
down.
there's
Oh, good.
just OAS attaching plates
Okay, fine.
and refusing to submit to arrest.
That's fine. I'll kick all of them.
So those are the 3.
Because the false plate was the probable cause for them stopping me, and the refusing to submit is a bogus charge, and the OAS cannot stand without the other 2.
Oh, and it wasn't a false plate, right?
No, it wasn't, and I've got it right here. So she wants to go ahead and push me into it, then fine. I'll expose everything I know. She's gonna wish she
But
hadn't.
they object to the subpoena. If you want, we could see what materials he brought.
I want the materials. I'm more concerned about the material that he brought than him.
Okay, well.
Honestly, I want the records more than I want him.
Go ask her, say, we'll forget about him, just give me the material. And we won't even argue about the subpoena. Just give me the materials he brought and we'll be done with it.
Did he bring anything?
That's what she said. That's what she said. So why don't you just go tell her that, see if she'll go get him.
Texted Kelly, and she said that Sandra said he didn't bring anything with him.
Oh, he did?
Apparently not. Why not?
Well, we don't know.
I don't know.
Didn't speak to him.
Right. And this is due process?
So,
What a joke.
so,
Man, I got so many
guess
grounds
we'll-
for appeal and it ain't even funny.
well, we can.
This is
I guess
absolutely laughable.
we can see what the judge says about the material. And the relevance of the material, that would be used
To impeach Shaw and Gay, yeah.
because
They're a bunch of liars.
because they have
And they falsify police reports.
It'll show their prior involvement and prejudice
Right.
towards you.
Right. What a joke.
Mike, is
We forgot the balloons and the clowns, Tim. I think they're waiting in the Volkswagen Bug out in the backyard. The balloons and clowns.
Yeah.
Yeah, it's the fucking circus.
Sounds like a little extra tough.
They expect them to stand trial with no evidence, no witnesses. No. And they say that they're following due process. I love it. Yeah, we'll see about that. Yeah, this ain't gonna be the end of this.
Well, yeah, the probate does the service, and they do it on that. I was told them that they're usually Surely won't pass on this. It may all turn out. It's just such a column that we they had. I don't know what they had.
Doesn't matter though, her criminal charges are going to come out of the music this is wrong. Right? See, the Santos doesn't even have legal
We just didn't have, we should make, we have one there. I mean, Tanisha Brown, I think Chris is not going to take that.
That's actually good news that they're going around three, because that means like intent and state of mind and like.
Now, two, what about?
Oh, and I don't know how it's going to survive. I don't know how you cut the legs off a dog and expect it to walk.
One,
The OAS.
count two. It's like a sign, but it's almost a property.
It's still a problem. But I didn't send in the case. And this one I got a little bit of research and the specific line. And I talked to some
So this is it, this is the only one.
See that date, July 2011?
Yeah,
You know what that is, right?
yeah.
Look at this. Violation free credit, violation free credit, violation free credit. And then 5/13/11, which is after the February and the March violations, right? So there's nothing between December 2010 and May 2011. So I don't know how you really do any kind of suspension for anything, because there's nothing there. And this is what I tried to show the judge. You know, we're talking about the prior offense, which is being used to enhance this case, was 2011.
right.
Correct.
That was
Which is
on
this,
council, that previous one.
which is this right here. Okay, that plea agreement was coerced because Steve Parker refused to look at this driving record, which shows there was no suspension to substantiate that OAS.
But didn't you challenge that in post-conviction? Or have you not?
I am still challenging it. It is now pending appeal
Okay.
to Maine Judicial. Mr. O'Connell is here to discuss the invalidity of medical suspension when it comes to prior offenses. A medical suspension, when it is removed, it is deleted, not restored. It's deleted, which effectually removes it from the record, which is what this proves.
Because you're saying that your 2011, you're not talking about this case right here, you're talking about 2011
Prior
conviction.
offense.
That suspension wasn't qualifying for a criminal charge.
That's
is that what you're
correct.
saying?
That's
All right,
correct.
let me take a look at your driver.
That's exact. And I have 3 different copies of the driving record here. And if you look at 2000, this is the public copy that I got on the morning of that conviction. I got this before my hearing in district.
Okay.
For the purpose of the hearing, okay? And if you notice the entry date, and if you notice the action date, it's May 13th, which is after the February, after the March date, okay? So there are no convictions. There's nothing here, which there should be. And there isn't. And Mr. Parker refused to look at this record before he convicted me on those OASs.
Why didn't they give you the rest of it? As long as it's not here.
Because this is a public record. This is a public record.
We were giving this.
There are 3 different types of records that come out of motor vehicles. Public record is your record, which only has entry and action date, and then there's the internal record, which has the delete date. We have the internal record here.
So you're challenging the basis of the 2011.
That's correct. That's correct, and that is under review. That's going to Supreme Judicial. I have agreed to do on January 14th.
Right, and so what I'm talking about today is your suspension for February 16th of 2012, which was for that conviction.
What I'm saying is, had Mr. Parker looked at this and recognized that a medical suspension cannot be used as a prior offense for a criminal charge.
Because of the change of the law in 2009, right?
I
Which
don't
is
know.
when they made
why-
some of them civil and some of them not civil.
Well, I know that my understanding of 329, the maximum anything could have been done was under 2412A8, which is traffic infraction. And even then,
Right, that's what I was talking about.
even then it doesn't qualify because A8 says only unpaid fine, dishonored check, or failure to keep insurance. A medical suspension does not rise to the level of any kind of infraction, does not rise to the level of any kind of offense. It was an administrative remedy only to get me to submit whatever piece of paper I need to submit.
Right.
And it wasn't even my fault. I was transient. If they claim that I didn't change my address, it doesn't even matter, because I was moving every 4 days. So even a 30-day change of address requirement wouldn't even have helped, because I was on the road. So my not getting that piece of paper for the medical request, which is what kicked this all off.
Right.
Okay? So when I got stopped by Eric DeSantos on February 10, 2011, there was a left turn violation, motor vehicle, computers were down, not to the status of the license, he set me on my record. Exactly 1 month later, he saw me at the exact same location, knew that I had that medical suspension, stopped me for the purpose of telling me about the medical suspension. There was no other cause to stop me. On March 7, 2011, he said, "Hey, Jimmy, you got a medical issue?" I said, "No." He said, "Well, medical DMV, they said, there's license under suspension." And I said, "Well, it shouldn't be." He said, "Well, you can call him." He said, "I'm sorry, but I have to give 2 answers today. One for today, one for a month ago."
So what did the court say before you were appealing it to the Supreme Court?
I did request post-conviction review, and I requested reconsideration of the denial of post-conviction. But that was filed prior to getting some of the evidence from this case, which gave me the grounds to do the ADC appeal. I did the post-conviction before the ADC appeal. And what's on appeal to Supreme Judicial right now is the ADC appeal tonight, okay?
Yep.
So what I'm saying is, the core action, at the absolute core of this, is my not getting into that request for medical review, which led to medical suspension, which led to this conviction, which led to these convictions.
Right.
Okay? And that's where I'm challenging everything. Because I was not even given the administrative hearings for medical that I was allowed to have. I'm still challenging that. And because the medical suspension was based on, but the medical suspension was based on incompetence. It was based on 2485-2D, which was incompetence, and they had no evidence in my driving record to prove or to even imply incompetence. I had 3 years of violation-free credits. How can they claim incompetence if I had 3 years of violation-free credits immediately prior to the suspended license? Is that evidence of incompetence, violation-free credits? How do they have any evidence to suspend the license for incompetence in the medical review if they had no evidence of incompetence? No driving, nothing.
But that's not able to be challenged in a particular venue.
But an OAS, the sentence for an OAS is contingent directly on the cause for the OAS. So if it was a failure to find OAS, it would come under traffic infraction under 8.
As long as
But if it was
you're
an
violation.
Right, but if it was an OUI, it would be much steeper. My point is, the basis for the OAS is what is the direct cause of traffic for the sentencing. Okay? The fact that my OAS was initially caused by a medical suspension nullifies any kind of remedy, because motor vehicle didn't even charge me a reinstatement fee. I was not charged any reinstatement fee, I was not charged any kind of penalty, there was no kind of sanction, no kind of restrictions, nothing whatsoever. All I had to do was fill out my doctor form, which I have a copy of, send it in, and they returned me right down home with nothing.
So is your license valid now?
No, it's not, it's actually expired now. And I have not traveled on my own since.
And the reason that she got this charge in the first place, she didn't.
It was an innocent.
She doesn't get the. She moves around so much, and she never really gets the notice. Any notices at that time.
At that time, I was transit. At that time, I was in between places.
It's not like she was, blatantly disobeying the law. She wasn't looking for it.
I just didn't get a piece of paper. As soon as I was notified, Eric DeSantis told me on March 7th at like 3 p.m. I went home before we were closed, and I made contact with them as soon as I got home. I got everything squared away by like noontime the next day on the 8th. And then when I got things squared away on the 8th, I came right to the district attorney's office. I spoke to them downstairs, and I said, "Look, this is what just happened. Eric DeSantis said that you would probably drop these cases if I shared this information." Wouldn't even talk to me downstairs. And then Steve Parker then railroaded me into a plea agreement. And in the courtroom, I said, "I plead a mistake. This is a mistake." I did. I plead a mistake. I did.
I wasn't here during all this
I
time.
know, it's the previous administration.
Yeah,
I'm trying to be easy on you guys.
So,
But that's what I'm
So, what I talked to Hank about briefly in the email yesterday, I'm talking to you about was dropping the prior. And be happy to leave just the first one. I also do a deferred disposition where at the end of the year, we don't get caught with any 590 violations.
I will do a deferred disposition, but I will not plead guilty to anything.
Well, under the rules, you have to plead guilty for a deferred disposition.
Then you withdraw your plea.
And then you withdraw it at the end.
That's the only condition with which I will plead.
I actually have.
I will
I
do
mean, and
that.
then you can get everything straightened out, your appeal, and get that all straightened out. I mean, you're not,
I'm not a
society, you're not hurting anybody, so if, and I was gonna try to get hold of me yesterday after this talk, because I ran into my search warrant. But if you want to hold a deferred disposition for a year, and you have no action in violation, at the end, I'll dismiss them.
Now, the only problem I have with that is, because of these two stops, okay? We've got the justice stop,
Right.
and the ocean stop. These charges for Augusta are separate from the civil traffic infractions that were already processed.
Right.
Okay? Same like we did with Oakland. There are civil infractions that were already processed in Oakland. Regarding Oakland, the fact that none of these criminal charges are being prosecuted, I'm going to challenge the civil infractions also because it's a probable cause.
Well, the officer was looking over.
Yes, I know.
And then the other officer, she says I was near the end of it. Yeah, he really did run into him. He wasn't. So I just I talked to him yesterday afternoon and just said it wasn't really worth it to even all over at that point.
Yeah, and I agree with that section because obviously what is the causative factor of Stubborn? Yeah.
Exactly.
So Stubborn had no foundation.
Right.
And the situation.
Right. And I literally just got this file the other day, so.
Yeah. So my concern, Joel, my concern, Joel, is if I go for a disposition on the Augusta case, how is that going to affect my challenging the traffic, the civil infractions that have already been adjudicated in traffic? That I'm going to challenge.
I would probably hang on this one, but I don't see.
I don't see any connection.
It's not a, right, because it's not technically a conviction, because you're not, it may be a conviction if you plead or get convicted and get sentenced. In the federal system it's different, but in the state system you have to get sentenced in order for it to be a conviction. And those I call those short forms, those traffic things. Those short forms are entirely separate from this, so there's a separate procedure, like Hank was saying earlier, to challenge those. So they would literally have nothing to do probably with the
But they
Right,
are.
but no one can say that you have a conviction.
Right.
Until you get sentenced,
Right.
and when you
And that
withdraw
won't
your guilty
happen
plea.
unless I violate the
Right,
disposition.
unless you violate Title 29A or commit a crime, like under Title 17.
So with this diversion or this disposition, would that release my bail conditions also? I'm not going to live on bail for next year.
Well, what's the bail?
$1,000 on security.
Oh, it's BTR.
I'm not going to live on bail for next year. Absolutely not.
Well, it's just PR, what do you mean
No, I'm
bail?
not going to live on bail conditions for next year.
That's
But there's no conditions.
Right, it's just don't commit a crime.
The only
Well, I have no
condition,
problem with
the
opinion.
only bail condition,
I don't like having the legal fist coming down on my butt by being a piece of paper saying I'm under bail conditions.
So you'll be on conditions of deferment. You'll be on deferred disposition conditions, but that's an agreement that the state and the defendant come to. It's not a forced upon thing by the court.
but you don't have bail conditions as such. The only bail condition you would have is you can't commit a new crime, which whether you have bail or not, you can't commit a new crime.
I understand what you're saying. I understand there are no actual elements other than not committing crimes.
Just the idea of it.
It's just the idea, yeah, it's just, the idea of, I'm a lawful person. I've never been in a situation before. The most that's ever been is a traffic violation. It's new for me. So having that hanging over my head it's tyrannical. It feels tyrannical, especially knowing who I am. I've never failed to be candidate.
Right.
So
There's
that's where I'm
in
coming
your
from.
case, there's no particular reason for law enforcement to do a bail check, because you
Right.
have no condition. There's no reason,
Right.
there's no reason for you to have any engagement. Well, on a deferred disposition, if you do have contact with law enforcement, you're supposed to, one of the rules is in the statute, you have to tell them that you're on a deferred disposition.
And that's something that I needed to know. I found that because the only other interaction I would have, probably not now because I'm not living in that place anymore, was when I was living on Sand Hill. I was calling as a complainant. Right. I was calling as a complainant. And that, you know, any moment is
That
there.
where your things?
Yes, yes,
Alright.
yes. And Peter Green for exactly 1 month for this arrest.
Yeah, but now you're not in that situation.
Right.
Involved in that. So, yes, we have 10 times more civil issues with me as a complainant than I have as a defendant.
Okay, so that's why you wanted the documents from Augusta to show that you're not the person they're going there to talk to about violating stuff, you're the person that they're going there to call.
That's correct. And also to show that Sergeant Shaw was a police officer on all of these, or not all of them, but most of them have, like all 30 times a day.
Right.
Sergeant Shaw was a police officer on many calls. The officer did in fact show up on one of the earliest civil calls, at which time he falsified a police report, which I have a copy of, and I filed an affidavit back in November 2011, rebutting this police report, press release. So I've had interactions with Officer Gay and Officer Shaw, where I confronted them about their unlawful reports and their ability to protect me.
Okay.
So we've had civil interactions that have culminated into where we're at now.
Okay, I see.
And the arrest that I'm being prosecuted on today happened exactly 1 month after Peter Cooley barged his way into my house and was found guilty of unprofessional conduct by Sergeant Shaw, and Sergeant Shaw also found him guilty of violating my right to the Fourth Amendment. 1 month before this happened.
Jeannie, you have to decide whether you want to agree to a deferred disposition, because there are some conditions.
I need to know
And
what
you
all
have
the
to be
conditions
on,
are.
what the condition is, in your case, you can't commit new criminal conduct, you can't violate Title 29, and you have to notify police if you're stopped. If you have contact with law enforcement, you have to tell them that you're on a deferred disposition. What about waiving the supervision fee? And then, but you're still gonna, the court has to, under these circumstances, of course, you're basically pleading guilty, and you're not sentenced yet. The court will still say that you're on bail. Your bail can change from unsecured, because you're not showing up all the time, to personal cognizance, and it's not going to be any bail conditions as such, but all people on bail, like people not on bail, are not permitted to commit a crime. So for
I have
people,
no problem with not committing a crime.
and that's the only condition. There's no other condition. It's not like, you have some kind of condition that the police need to do a random search or that they have to check on you. And it's not the way where you're living now. It's not like you're in an environment where there's going to be police coming to the area for any reason.
Right, exactly. I have no problem with these environments.
Right.
You know, so. And
So if you want to do that,
I would like to, I mean, I'm not going to plead guilty to anything, I'm not guilty. I mean,
well, you have to.
Oh, you mean to be sentenced?
to be sentenced, right?
Right, and you're not getting convicted.
Right.
You plead guilty, but you don't get convicted, and then it's continued sentencing until the next date, and then the next date, you come in and you withdraw your guilty plea, and then the case is dismissed, and then the court record reads case dismissed. Yeah.
And so the plea today will actually be for disposition.
If there's a separate form, it'll look like, it's a court form. I'll go down and grab one, and Hank, and you can go over it. And it's basically, it's a contract. It's basically a civil contract. And, you agree to do certain things like not commit crimes and not violate Title 29A and talk costs that you're on deferring. And then I agree at the end of 12 months, if all the conditions are met, that you are allowed to regard the plea and the case is dismissed.
Okay. And just for grins and giggles, just so I know what all my elements are, what happens if for some reason, that 12 months, one of those violations,
Well, at that point, you're entitled to a hearing. You do get your hearing. It's a different kind of hearing. It's not a beyond a reasonable doubt standard at that point.
and you're talking about just the 286 here. on this case.
Right, just on this one count. So it'll be, well, we would file a motion, and then you get notice of it, and then you have to come, and you can have a hearing, kind of the same thing we're doing now, except the rules of evidence don't so much apply in those particular hearings, because they're considered miscellaneous. It's going to have to be your,
Right, it's kind of like probation.
right, yeah.
But an important thing to remember, if for some reason you violate the conditions of the deferred disposition, you have entered a guilty plea in this charge. So that means when you enter a guilty plea in this charge, you are giving up your right to a trial. You can't have a trial later.
Okay.
You give up your right to a trial, so there's no more chance for a trial.
Does a deferred disposition eliminate my ability to withdraw my guilty plea later on?
You can always
Can I always withdraw a guilty plea?
say that again.
Withdraw, because let's say right now, let's presume I play guilty right now, straight up. Later on, let's say 2 weeks or 2 months down the road, I can withdraw that guilty plea. Under deferred disposition.
If you're not sentenced.
Right.
Right, I'm not saying.
It's possible. It's not
Under
guaranteed. It's
this
possible.
deferred disposition, later on, let's say 9 months down the road, I want to withdraw the guilty plea. Is it still a possibility?
I don't believe so.
Okay.
Where you can, I think it would be the same.
I'm sorry, I understand the question.
I'm just looking at all the evidence. I don't even know what's wrong. I'm just looking at what all the
If you
elements
plead
are.
guilty,
If I play guilty under deferred disposition,
you can withdraw at the end unless you violate,
I can move.
unless you violate the terms.
Okay, so I can withdraw the guilty plea at the end of the year
Right.
unless I violate.
Right.
Okay.
And if you violate,
Okay.
and the court, then you can have a hearing on it, whether you really violated. And then it's going to be up to the TA to decide whether they want to let you withdraw nonetheless, even though you violated. But there's nothing you can do. It's completely up to them. If at the hearing the court found that you did violate.
Well, I have no problem with
If the court
violation.
found that you didn't violate, then you just go back and you continue
Okay.
until the year's up, and then you withdraw your plea.
All right. Well, I'm not concerned about any kind of violation. I just want to know what all the parameters are before I do this.
Yeah, I'll grab the forms and press them.
Yeah, that'd be great.
It is a brief form too.
Well, I hear what you're asking is if whoever easily decide to talk about here.
It's a little more than 2 years old. Almost 2.5 years old. No, let's put it on hold for 2 years.
This would only take me almost 2 years.
I'm going to sell it. Mm-hmm. Laughing just like me. Good condition thing. So how's this whole call going? Terrific? I miss what you want. Where are you now?
I'm in a separate division.
Are you?
Hey, you got the deal you're not going.
Yeah. Oh, yeah. I see a picture of it before I found my name. Sounds at some point. But I have a question for you. My understanding, based on my A medical suspension is not an unidentified offense when calculated OAS. I've never used a medical suspension in any of my OAS or otherwise calculated.
The problem is the way the statute is structured. It doesn't come under the traffic infraction, so by default it would be criminal. It wouldn't come under the traffic infraction. Oh, yes. Yeah, you have a, yeah. So if it doesn't come under that, then it's got to be a criminal offense.
But how can, okay, second question. When you look at the driving record,
Yeah.
it shows that when a medical suspension is restored, it's actually deleted.
Right, it's not restored. You're correct what you were saying.
Actually,
It's deleted and there's no fee sponge. But
It's spun.
It's set aside.
Right. Well, but yes.
But that is a different question than what happens if you're driving while you're under that suspension, even though it's subsequently deleted. That's why you're in that.
Right.
When we're back.
Right, so the deletion, effectively cleans the record of that offense.
Please, the suspension.
Okay. So there's no fines, so it never actually happened. Because
I don't think that's the case. I think if any conduct, if you're driving during the term of suspension, then it's going to be an issue.
okay, the fact I didn't know about analysis college, and also, was Eric DeSantis was the person who told me about suspension. It was him informing me.
Right.
Right. And I immediately fixed it within a matter of hours. But that didn't stop the train from being down and moving on to hell. You know, and this is what my correspondence will be in the last 7 months of the job. Because I never got my straight here because I never got my post suspended.
Right, and there was another notice that was sent you before that basically says you got to file a report by X date. And if you don't, then you're going under suspension, then the suspension notice was prepared.
Well, the problem with the suspension notice though was, the first notification was in November of 2001. The second one was in December of 2001. Both of them were returned to motor vehicle.
Yeah.
So it was on the record, it was returned.
Yeah.
And then the suspension went into effect within 10 days of that second year of the return.
Yeah.
So the state came and pointed out about the notice, so the record shows how they did that.
I think the state's going to argue that the actual notice is not right.
But actually it is, between my day, 3482, I believe it is, says that notice is being received unless returned by postal.
That doesn't address the issue. If you didn't receive it, you still be convicted of an operating act suspension. And I think there's a series of cases that says actual notice is not required.
I understand what you're saying. I understand. So this is big old pivot one that I've been traveling for the last 20 years. Is, you know, this big old mess. Yes, everything's in order.
So they're going to dismiss one.
They dropped everything except one charge.
Okay, so we're going to plead to the OAS, the girl for whatever period of time. And then at the end of that period of time, it's going to be dismissed. So we're going to go right now.
Thank you, Ben. You're welcome. It seems to address making sure that components right. See, I didn't need to do anything more. Is there any?
sign it when you go before the judge. Right in the document. 212, 286.
How is this supposed to that probably more question for B&B, but it's not a conviction, so they, on OAS, is they usually only act if there's a conviction, the court sends them an abstract, and then they act on that. Bob, you got a cigarette on there?
What?
You got a light too?
Smoke it right there.
No, I think I can handle that, but I left mine at home and.
I wonder if we're going to have to get Oh, it's just bring him back here at 12:30 because he's in Carroll.
I'm gonna go outside for now.
Oh, yeah, that's right. So I don't know, yeah, I don't know the daily schedule with them and stuff like that.
The only reason, I guess I got appointed, or she got a lawyer, was just because there were so many charges.
Probably, yeah.
And she had two previous lawyers.
Yeah.
They were trying to get it off. That was the problem. So, we're all set?
Yeah, I think she wants that 1 o'clock.
You don't need to speak to the judge now, or do you? Oh, you can tell the judge that. Well, she wants to see it, I think she's getting ready to run out, so look at this. Yes.
No worries.
that we're managing every case. Every case.
You just have a seat back there, please. Oh, thank you. Make sure yourself on the road.
Yeah.
Thank you.
Did you file dismissals?
Well, I filled out one, but I didn't know they merged, I didn't know they numbered 1 through 7. I thought they were still kind of separate, or just doing them together. So I have to fill out another one because I put one through, I just put the old docket
I
number.
guess we could just verify with the court that cases have been joined, because there has been some.
This morning, right.
So they talked this morning.
Yeah.
And, they can-
Right, yeah. Sometimes when it's consolidated, they don't really consolidate.
Because I need a copy.
So did everything go under 12-286?
Yeah, even under 1286.
Do you know who I talked to challenge the traffic infractions that were charged at the same time that these charges were charged? There were traffic infractions that were processed through traffic court prior to, like, did I know?
Did you admit that?
Huh?
Did you admit that?
No, I contested them.
They found you had committed offenses?
Well, yeah, they,
You already have a appeal hearing?
I didn't know enough back then. I learned a lot of the last year and a half.
And you pretty much know the appeal period is passed.
What about new evidence? These charges were dismissed, so could that be new evidence that these charges and probable cause were dismissed? So that would nullify
Make
those
that
charges?
action, whether that allow you to reopen the case.
Okay,
Have you paid the fine?
no,
Well, that might help you.
no, and as a matter of fact, there's like $350 reinstatement fee waiting on my driving record too, because I've not paid anything. Yeah. Because I've contested everything, it's been wrong from the beginning. So I've not paid any, and the only thing I did pay was the OAS fine from the 2011 conviction because Judge Dobson threatened me with jail time. She said, either you pay it now or you take me to prison right now. So I said, I'll pay it under threat to rest in court so I can keep my freedom. That's the only missing payment.
Okay, what prosecutor was for those traffic infractions all Kennebec?
Yeah. Yeah. And that payment occurred in December of 2011, I think. So yes, I have fees and fines and stuff pending because I refused to admit them.
All rise. Kennebec County Superior Court is now in session. Honorable Justice Kayla Murphy presiding.
Please be seated. This is CR-2012-286, State of Maine versus Gina Turcotte. Ms. Turcotte, you were probably expecting Justice Martin. He had a family emergency, so I'm calling in for him this morning.
That's fine.
I was just told by the jury officer that there may be an agreement in this matter.
Yeah, sure. Upon preparing for the case yesterday, I know they're now merged into two different cases. I'll still refer to them separately. The docket that was originally 12-667, the Maine officer in that case is now deceased. He had a sort of a backup officer who arrived near the end of the event.
That's the allegation of refusing to submit.
It's a failure to stop violation of condition police, OAS, and probably that officer has since been deceased. The backup officer that arrived after the stop was initiated didn't really remember sufficient facts. So I agreed to dismiss those. Regarding 12-286 counts 1 through 3, Counts 1 and 3, I was dismissing before the trial today, so I think specifically we're talking about count 2, which is the operating after suspension. Ms. Turcott is going to enter a guilty plea for a deferred disposition for 1 year. If she doesn't violate Title 29A or 17A, she will have the OAS dismissed. It's my understanding that the prior conviction for the OAS, which is what triggered this suspension, is being challenged at this point to the Supreme Court.
Right.
So that appeals for
I'm familiar with that. In that case, I mean, you got your license back, did you not?
No, Judge, I don't. No, and as a matter of fact, it has expired. It is now expired,
The
yes.
suspension, you got reinstated.
No, I did not.
Okay.
Because I won't admit to any of those charges, so I've not paid any fees.
She was medically suspended, that suspension was rescinded, and then the conviction came through based on a medical suspension, which is what I understand is being challenged now. I think the deferred disposition with those conditions satisfies the state's interest and complies with Title 29A if she is driving on public way or parking.
Okay, so if there is a violation during the next year, if she breaches the agreement, what is the worst case scenario, an open plea?
Yes.
And what does that mean, ma'am?
What that means is, well, first of all, if things go well, you're not going to have convictions for anything that occurred back in April of 2012 in Oakland.
I'm sorry, February. The Oakland one has been dismissed. The Augusta one is, the Augusta OAS on February 16th is the one she's pleading.
I don't have that file.
They were together. It's a merged case.
They were merged after time of selection.
They were merged a while ago. July 2012.
Right, so what I have on the complaint is counts 4, 5, 6, and 7 on one complaint, and count 1, 2, and 3 on another complaint.
Correct.
Okay, so the February 16, 2012, refusal to submit to arrest in Augusta is being dismissed.
Yes.
The operating after suspension is the guilty plea. Count 2.
Yes.
Count 3 is being dismissed, which is the improper place. Count 4 is violation of condition of release. Count 5 is another operating after suspension. Count 6 is improper place, and 7 is failure to stop. 4 through 7 are being dismissed as well.
Yes.
So you understand what a deferred disposition means?
Yes, Judge, I do.
It means you come back in 1 year, if things go well, the final charge, which you would be pleading guilty, would be dismissed.
Okay.
If things don't go well, the court can impose any sentence as authorized by law up to the maximum, which would be incredibly rare to see a maximum sentence for Class E OAS, but you just have to know coming in, I guess it's 6 months is the maximum for Class E, that that's a possibility. So knowing that, Mr. Crowe, how do you think it comes to operating after suspension Class E?
Guilty under the deferred disposition.
Okay. All right, so all the other charges have now been dismissed. I'm going to move out all the motions that were filed by both sides, including motion to quash and motion to litigate. And are you asking for supervision to be heard? All right, so nothing happens now. We have to come back here and litigate. We're going to give you a date before you leave for your term. And if things go well, the only thing that happens is it comes in courtroom and you're told the case has been dismissed.
Okay.
If there's been any violations, then the court would consider what happened and maybe impose a fine or something depending on what the violation might be. Hopefully that won't be any.
No, that won't be a problem, no. With regard to, will the court send me any kind of reminder a month or two before the date, or
We're going
is...
to give you a copy. You go to the court's office before you go. The date and time for you appears on this piece of paper. They're going to give you a copy, but that's what you're doing.
Okay, and that will be the only notice?
That will be the only notice.
Okay.
Mr. Hainke will also get a notice as well.
Okay.
I'll remind you ahead of time.
Okay, so I have to put a tickler in my calendar then?
That's probably good. You'll have
Okay.
a copy now.
Okay.
Are you asking for your mom? No. Okay. No. All right.
Okay.
This defer this position, have the box checked to not bail on, so just blank that out. So there's no requirement. All right, so that answers for you, Mr. Dr.
Thank you.